Correct. So that's not the case here, Malad. On 21st of June, they were in Gujarat and they were in the Northeast, only the legislative members. And they never said there's a split. They said we are the Shiv Sena. So that claim was also not there. Then came the 91st Amendment, 2003. Sorry, 2000. 1st January 2004. No. Yes. It's an act of 2003, but came into force on 1st January 2004. 10 Yes. Now, let us kindly see this constitutional amendment. They amended 164 of the Constitution, which you will find, Malas, in PDF page 52. In article, I'm sorry, has Article 164 of the Constitution, after clause 1, the following clauses shall be inserted.
Where are we?
Well, is that PDF page 52?
PDF page 52, yes.
Well, this is the amendment starts, Madhus, at PDF page 51. And the relevant part, because 1A and 1B were added. And if you see section 3 of that, in Article 164 of the Constitution, after clause 1, the following clauses shall be inserted, namely 1A, the total number of ministers, including Chief Minister and the Council of Ministers in the state, shall not exceed 15% of the total number of members of the Legislative Assembly of that state, provided that the number of ministers, including Chief Minister, shall not be less than 12. Provided further that the total, we are not concerned with that. 1B, Malas. A member of the Legislative Assembly of a state or either house of the legislature of a state having legislative council belonging to any political party who is disqualified for being a minister of that house under paragraph 2 of the 10th schedule shall also be disqualified to be appointed as a minister under clause 1 for duration of the period commencing from the date of his disqualification till the date on which the term of his office as such member would expire, or where he contests any election to the Legislative Assembly of a state or either house of the legislature of a state having legislative council, as the case may be, before the expiry of such period till the date on which he is declared elected, whichever is earlier. This also creates a lot of problems. That problem doesn't confront us in this case, because most of these people then resign, join the other party, get elected, become minister. So there is some scope for challenge to this particular provision, its constitutionality. But be that as may, we are concerned with the earlier part, that if you are disqualified, you can't be a minister. Now, your disqualification is pending. Matter is before the Constitution bench. Matter is before the Speaker, whichever it may be. And you are appointed by the governor.
And also there's a provision on the Representation of People's Act where they can't contest again.
That's right. Not for this, Malas. Not for the 10th schedule. That is for other corrupt practice. There's no period here. That's why I say this is subject to challenge.
Okay.
There, Malas, if you for all kinds of other reasons, corrupt practice, and he's been convicted for X number of years. Normal is what is happening in a ordinary case of a dharna on a road. A trial court convicts you for 2 years and you lose your membership of the Legislative Assembly. That's also happening. We can see it, headline news everywhere. What do we do? Can't keep on coming to court every other day. Your lordships also get fed up with us. Sorry.
We have already.
How many times do we give you justice? Now, kindly now come. So, Malad, therefore, now the bottom line is there is no concept of a split anymore. Then the statement of objects and reasons for deletion of the paragraph. Paragraph at PGF page 54. That says para 2, Malad. The Committee on Electoral Reforms. Demands have been made from time to time to in certain quarters for strengthening and amending the anti-defection law.
Where you reading?
Well, that PDF 54, the objects and reasons of the deletion. Yes, yes. May I read that, Malad?
Yes.
Yes.
Demands have been made from time to time in certain quarters for strengthening and amending the anti-defection law as contained in the 10th schedule to the Constitution of India, on the ground that these provisions have not been able to achieve the desired goal of checking defections. The 10th schedule has also been criticized on the ground that it allows bulk defections while declaring individual defections as illegal. The provisions for exemption from disqualification in case of splits as provided in paragraph 3 of the 10th schedule to the Constitution has in particular come under severe criticism on account of its destabilizing effect on the government. Please see this, please mark this. The purpose of the amendment is that we will not allow you to destabilize the government by bulk defection. And that's exactly what has happened here. So you have to interpret the 10th schedule and its provisions to ensure that there is no bulk defection. And the concept of minority is over. Bulk majority also will be subject to disqualification. And 1/3 was a defense. Majority is not a defense anymore. There is no defense as far as the split is concerned in the legislative party. Well, that's paragraph 2 there. The Committee on Electoral Reform, Dinesh Goswami Committee, in its report of May 1990, the Law Commission of India on 170th report on reform of electoral laws, 1999, and the National Commission to review the working of the Constitution, in its report of 31st March 2002, have inter alia recommended omission of said paragraph 3 of the 10th schedule to the Constitution pertaining to exemption from disqualification in case of splits. The NCRWC is also of the view that a defector should be penalized for his actions by debarring him from holding any public office as a minister or any other remunerative political post for at least a duration of the remaining term of the existing legislature or until the next fetch elections, whichever is earlier. It is proposed to accept these suggestions.
Mr. Sibal, notwithstanding the deletion of paragraph 3 of the 10th schedule, the issue as to who represents the political party is still a moot issue.
No, Manoj.
But that has to be resolved outside the legislative party. That,
No, Manoj.
that cannot be still, according to you, resolved within the fold of the legislature party.
Manoj, that question doesn't arise in this case because this,
No, I mean, we're not on this case, but that question as to who represents
well, that will happen outside the house.
that will happen outside the house. That cannot be resolved by the number of legislators within the house.
That's my only submission, Manoj.
Yeah.
How that is resolved outside the house is actually given in a judgment of this court in Brahmanand Reddy.
Brahman.
That's
I'll
a
issue-
matter of the internal, the internal constitution.
That's right,
the-
that's
the-
right. You have to call a meeting, you have to raise the issues.
The
Manoj,
internal
for 2.5 years, the gentleman was a minister.
The procedure, the bylaws of that party.
Yes, yes. Yes.
But the forum is.
You have to follow those bylaws. You have to call a meeting. You have to resolve that issue. And then you can do all this, Manoj, when paragraph 3 was there. Otherwise, Manoj, what you're doing is exactly what the object says you shouldn't allow to do, bulk defections. Toppling the government. As I said, what this would result, if you were to uphold this, Manoj, my humble submission, if you were to uphold this, then any government can be toppled, Manoj, for the simple reason you take those people, become majority, appoint your speaker, Manoj, and have a trust vote and you are in government. You don't need anything else. You don't need to have a split in the political party. That's a matter of Manoj, a dispute that will arise and it will go to courts and the courts will decide in their own time, Manoj. In the meantime, the 5 years will pass. So if you wanted to remedy this menace, you can't allow the perpetuation of this menace by recognizing a split in the legislative party as if there's a split in the political party, which is not even addressed, which is not even claimed. What is claimed is that we are the party. No, we are the party can't be claimed within the legislative party. Well, that's for 2.5 years. I'm sorry.
For 2.5 years.
He was the minister. This very government never raised any issue. There is no public document saying that he is dissenting or he's a conscientious objector. Nothing. No evidence, no document filed, no evidence of that, no public statement, no newspaper report, nothing. He was the leader of the House till 21st of June. And overnight, Manoj, facts stare you in the face. The only way, Manoj, this is not what Parliament will be ready to do. The only way to remedy this is to have a 5-year period of no public post moment you defect. No minister, no public post, no public sector, no nothing. All this will stop. That's the only way. 164, 1B now gives you a way out. Instead of defecting, you can resign. And then you become minister. You were a minister before, all you have to do is resign. This is the only way. If you want to maintain morality in public life, you will not be given any public office, no governorship. No remunerative post.
Kind of cooling off,
I'm sorry?
cooling off of sorts.
Yes. Even in 361, Malaj, in fact, disqualification for appointment on remunerative political post. Capital B, Malaj. If he was disqualified, he can't hold a remunerative post. Actually, 91st Amendment, Mullahs, was very careful in trying to sort of settle part of the problem. But one thing was clear, they did not allow for bulk defections. Now, Mullahs, paragraph 4, if I may read, Mullahs, of 10th schedule. Oh, one, Mullahs. Just waiting for my lady, your ladyship. Okay. A member of a house shall not be disqualified under subparagraph 1 or paragraph 2, where his original political party merges with another political party. And he claims that he and any other members of his original political party have become members of such other political party, or as the case may be, of a new political party formed by such merger. So, Maharaj, if the Congress or if a small party in a state merges with another big party to form a new party, that becomes his original political party. Therefore, a member of a house shall not be disqualified where his original political party, maybe a small party, merges with another political party, and he claims that he have become members of such other political party, that is, they merge into that party, or as the case may be, of a new political party. Both of them may form a new political party formed by such merger.
So A merges with B, or A and B merge together to form C.
Form a new party. So therefore, no disqualification. It's a merger of the political parties. Or have not accepted the merger and opted to function as a separate group. So I say, look, I don't accept the merger.
There's no compulsion to merge.
There's no compulsion. I may be majority, I may be minority within the legislature.
This will be called the unattached member?
Yes. No, but if he has not merged, Malaj, he can form a separate. He will belong to the original. Supposing two parties merge and form a new party. Correct, Malaj? And he belongs to the original political party on which he won the election. He will continue to be the original political party.
I think Amar Singh sat like that.
Amar Singh, yes. He will continue with the original political party. That also issue is before the larger bench. So, if there's a new political party formed pursuant to merger, and I belong to the original political party on the basis of which I was elected, I continue to be in that original political party.
But clause 2 now again has
I'm coming to that.
requirement.
Yes, I'm just coming.
It is 2/3 of the existing
Correct,
members of the
That's
legislature.
a very interesting provision, which
Kind
of
of a
course
clause.
doesn't call for interpretation now, but it has some nuances that's important for us to understand. And from the time of such mergers, such other political party or new political party or group, as the case may be, shall be deemed to be the political party to which he belongs for the purposes of subparagraph 1 of paragraph 2, and to be his original political party for the purposes of this subparagraph. So from the time of such merger, either to a party or to a new political party, he is deemed to be a member of that political party to which he belongs for the purposes of paragraph 1. So may belong to that original political party and is dissociated himself, or after merger, he belongs to the other political party. No issue. Now comes the problem. For the purposes of subparagraph 1 of this paragraph, the merger of the original political party of a member of a house shall be deemed to have taken place if and only if not less than 2/3 of the members of the legislative party concerned have agreed to such merger. Now, my lords, if 2/3 of the members don't agree, then there is no merger as far as the legislators are concerned. First, the merger takes place. Then the question arises whether you are 2/3 or not. If you are 2/3 and you agree, it is fine. It's a defense. If you are not 2/3, my lords, then you can be a separate group. So 2/3 happens to be a defense after the merger.
This deemed is also very important
Yes.
because what 10th schedule does is that it doesn't create a new category. By saying deemed, it is relating back to the position of the assembly as it were
Yes.
when people, legislators got elected and come to the assembly.
Yes.
That position will be deemed instead
Yes.
of creating a new category.
Correct. For the purposes of one, the merger of the original political party of a member of the House shall be deemed to have taken place only if not less than 2/3 of the member concerned have agreed to such merger. So 2/3 of the member, less than 2/3 of member, question defense doesn't arise. But if 2/3 of the members agree, then that's a defense. That's a perfect defense. So, looked at it from any standpoint, these 40 people have no defense under the 10th schedule. They don't claim that there's a merger. They say that they are majority in the legislative party. They claim that because of that majority, they can change the whip. They claim that they can change the leader of the House. They can call themselves, Eknath Shinde can call himself the leader, merely because he happens to be one of 40. And so what happens, to the political party to which he belongs? What morality are we talking about? What conscientious objectors are we talking about? Conscientious defectors is the word that I used last time. And you don't raise a voice for 2.5 years. You are the leader. You enjoy the fruits of ministership. And suddenly you say that, look, now I am free to do what I want. I can join up with the BJP. I can go to Guwahati or wherever I want to go to, and that's it. So the question that your lordships will have to ask, how does the 10th schedule come to their aid at all? Under what provision of the 10th schedule can they have a defense? The schedule doesn't give them a defense. Whether it's a minority bulk moving away or a majority moving away. Which is when we last time were discussing this matter, this is what I mentioned. That the 10th schedule doesn't make a distinction between majority and minority. It just ensures that this habit of bulk defections, which is destroying the polity of this country, and by which elected governments can be overturned. The objective is that you should not allow an elected government to be overturned. That's the fundamental premise on the basis of which paragraph 3 was deleted. You cannot destabilize government. And if you uphold such an act through a judicial process, you are enabling future defections and therefore destabilizing elected governments, which has far-reaching consequences for the polity of this country. That's the issue that your lordships have to decide.
Yes.
Well, it's paragraph 6 of the 10th schedule, but well, I'll take up the next topic tomorrow, well, if you don't mind.
The transcription which we have made is from description is cleaned up in the early part of the evening. We'll give you a copy so that you can have a look at it if there's something, you know.
You can know what you argue.
Oh,
And don't-
that'd be wonderful.
Don't file an application for amendment.
No,
No. Thank you. I appreciate it. I hope you continue to be well. I'm sorry, but
we debated, to argue one by one.
I agree.
Both at a time.
well, as posterity will also get to know what foolish arguments we made. Well,
And also good arguments.
But
And of course,
nobody admits.
but it's we will, of course, this will be a great record for the board.
Yes, yes.
It will-
No, I think it's a wonderful
it
idea.
will Truly a court of record.
Yes.
Because every word is recorded.
It should be. It should be.
Every word is recorded.
Court of record.
Well, in fact, I can share something with you. When I was practicing in New York, we have these EBT proceedings, that is examination before trial. And I'm talking about about the 70s. Well, they would record everything that was said in the course of that examination, even then, so that we know lawyers knew what was going to happen.
Gujarat has e-court in the sessions division, sessions courts, where even our internal whisperings are also recorded.
That's very dangerous.
News and-
That's hazardous, completely hazardous.
Now, the only thing is that if there are two or more voices at the same time,
Yes.
that causes a little bit of a problem, but they obviously have personnel who will clean up the errors by the evening. They suggested that during the course of the day, the council will get the link, so the council can look at it. By the evening, they would have cleaned up the entire transcript and given it to us. So
That's wonderful. That's wonderful. That's truly
In VC
Truly
proceedings,
a milestone, I would say, Mother.
in VC proceedings, anybody wanted to interrupt would lift their finger. So much there is no crosstalk.
That's
So
right.
we can follow that pattern so that it won't
Hopefully.
overlap with one another.
So, Malaj, Let me just give your lordships a broadside view, Malas, of what is in issue here. Then I'll go on to the matter in some detail. Malas, as your lordship knows, Malas,
Pen drive last time ka. Yes,
what is in issue is whether
last time ka.
the legislative party, that's the central issue, whether the legislative party in the House acts independently of the political party. That's the central issue. Because I will, Malaj, while I go through the facts before your lordships, indicate to your lordships that on the 21st of June, when the first meeting took place, and we called, the group led by Uddhav Thackeray called members of the legislative party who belonged to now the Eknath Shinde group to come and attend the meeting, which was not done, pursuant to which some actions were taken. The contention throughout has been that there is a split in the party. So the issue before your lordships is, can members of the legislature within the House or comprising of those members of the House by themselves say that there is a split in the party because they don't agree with the leadership? This in turn would require your lordships to look at the 10th schedule and in that context, interpret the role of the party within the legislature. Because after all, members of the legislature of any particular party get elected on a symbol of the party. They are there because of the party. And if they are there because of the party, Malaj, there is an umbilical cord link between them while they are sitting in the House and the party outside. Can that link be severed and say, we are an independent set of people, we can do what we like? That will require, Malaj, the interpretation of the 10th schedule. It requires your lordships to analyze the role of the whip, how a whip gets appointed, how he happens to be a bridge between the legislative party and the political party. And that nothing happens in the House without the political party taking a decision. Nothing happens. Well, the bill is introduced by the Treasury benches, any bill.
So is it your contention, therefore, is it your contention, Mr. Sibal, therefore, that unless there is a split outside the House,
Yes.
within the political party,
Yes.
that split cannot find recognition within the legislative party within the House? That's your...
Absolutely. That's my contention.
It could
That's the law also, Malaj, and I'll demonstrate that to your lordship. That is the law. Well, what happens, Malaj, that I'm giving your lordships an example, Malaj. A bill is introduced by the Treasury benches, a controversial bill, let's assume. Bill there in which there is no consensus. Malaj, what happens? The parliamentary party, a group of members of the legislature are invited by the parliamentary party to sit outside the House in a particular room and say, this is the bill that's being introduced. What should be our position? The party decides the position. And it's articulated in the House. The legislative party by itself, dehors the party, doesn't decide what we are going to do, what you are not going to do. When a whip is going to be issued, Malaj, it's issued outside the House, translated inside the House. Okay, on this, you're going to vote against the bill that has been introduced, or that you will vote in favor, or that you will abstain.
But when the 10th schedule speaks about, say, a merger, for instance, now
Yes.
there are very few exceptions in the 10th schedule, and it speaks of a merger.
Yes.
Uh, ultimately, the speaker has to decide whether there is a merger. The speaker will not go into whether there was a merger outside the house, because then the speaker will be taking over the function of
No,
the
no,
Election
that's-
Commission of India.
Malad, that argument is entirely on a different plane, Malad. So we're not dealing with it, and we'll interpret the
Because-
paragraph 4 for your lordships also.
The speaker's remit cannot lie outside the house.
Mullah, there's a problem. Supposing, all right, then let's analyze that for a minute, Mullah, since your lordships have raised the issue. Mullah, supposing there are 10 members of the legislative party in the house, right? And the merger has to take place of the political party. They belong, say, to the Mullahs, to the Samajwadi party, right, Mullah? Now, even paragraph 4 says that there's a merger of the political party, not the merger of the legislative party.
Right.
Right? So therefore,
But if we
Samajwadi party has
accept
to
your
merge.
argument, but no, if we accept your argument, that would mean that unless the Election Commission of India decides on a merger outside the house, the speaker cannot take a decision within the house within
no,
his
Election
constitutional
Commission
remit
did
on
not
whether
decide.
there is a merger or not. That can't be.
No, Election Commission did not decide this issue, Mullah.
How else?
Because a resolution will be passed that we have merged. And that will be informed. The Election Commission, they don't have to take a decision. They'll be informed. Majority of the members of the party will decide, they'll be informed. Once merger takes place, these eight people may say, we don't want to merge. And paragraph 4 says they need not merge. But I'll come to that later. This is a very complex issue, actually, not so.
Let's have a broad now framework of the facts, because
I will, Manoj.
in fact, that was our basic problem there. Unless we have a clear perception on the
I'm going
facts,
to
it's
do
very difficult for us then to look at the law divorced from the facts.
I entirely agree, but just, Manoj, may I just, your lordship, what are the issues that are going to be? I just
Yeah,
told your
that's
lordships two.
We have to necessarily reframe the issues, because the kind of the issues which are there, which are
Yeah, it's not reflective of Mullah, what needs to be decided. I agree entirely. Mullah, the other issue is, and that's never come up before the court. And that issue is, can a governor swear in a member of a legislative party against whom a disqualification matter is pending before the House? That's the other issue. Never come up before. What then are the powers of the governor in matters in relation to disqualification? This is not a case of a pre-poll alliance. This is not a case of a post-poll alliance. This is not a case of one political party. It is a case of people who allege that they are the party because they are a majority in the legislature. Right, Mullahs? What then are the powers, or what should be the function of the governor in matters of this nature, and how he should conduct himself? Because he also knows, because the disqualification petition is pending, Mullahs. He also knows. And if the governor does, Mullahs, swear him in as a chief minister, Mullahs, he actually topples a democratically elected government and aids in doing that, because they happen to be majority in the legislature. Well, that's one of the issues that your lordships may have to consider. Then the other issue to be considered is, can a court, constitutional court, without referring the matter to the speaker in the facts and circumstances of this case, decide the matter on its own, given the fact that there are no disputed facts? We are not going to, Mullahs, place before your lordships any disputed fact. All are matters of record.
Your question is, can a constitutional court decide 10 schedule?
That's correct.
10 schedule.
Yeah, that's correct. That's correct. That's correct. Because under the 10th schedule, it is the speaker to decide, Mullahs. Correct, Mullahs? But if the proceedings, Mullahs, are imbued with illegality, And given the conduct of speakers in the past, what then should be the attitude of the court in a given matter? That's the other thing. And then, of course, lastly, Malaj, how do you deal with an issue? And that, Malaj, because the last question in the reference is the powers of the Election Commission. And your lordships, and that's the last question, which is the last issue your lordships will have to decide, that under paragraph 15 of the symbols order, when there is a split in the political party, it starts with that proposition that two factions have arisen pursuant to a split in the political party. Then which faction should get the symbol?
Will that arise in this case?
I'm sorry?
Will that arise here?
Yes, that's a question. That's a question. What is the role of the Election Commission in matters under the, that's part of the reference.
So under paragraph 15 of the symbols order, when two factions emerge in pursuance of a split.
Yes.
So what is the sequitur? How would you end the sentence?
Well, then what is the role of the Election Commission in deciding that matter? Should it await the decision of the Constitutional Court? Should it go ahead? Your lordships only, Malaj, as your lordships will remember, in September said no stay. But your lordship did not say how he is going to decide it.
But that, Mr. Sibel, is your independent challenge to the order of the Election Commission.
That's a separate issue, Malaj.
We can't really decide.
No,
that
that's
issue.
part of the reference, Malaj. I'm going to argue, Malaj.
How do we, he's saying,
Constitutionally, the Election Commission cannot proceed. Malaj, the split would would have to happen on 21st of June. There was no whisper of a split on
is
21st of
your
June.
contention that therefore the Election Commission itself cannot proceed until
Yes.
the Speaker has decided.
Correct. That's what your lordship said. No stay, fine, Malaj, no stay. We went before the Election Commission and said, you cannot decide this matter. The matter is pending in Supreme Court. He said, no, but Supreme Court has said no stay. And you will find that tomorrow, Malaj, when your lordship sit at 3:30. But be that as it may, that's the last question that your lordships, your ladyship will have to look at. So these broadly, Malaj, are the issues that you might be asked upon to decide, Malaj, that you might wish to decide. Now, Malaj, let's go to the list of dates, because unless you have the facts, Malaj, it will be. Malaj, this is now PDF page 108 of the written submissions. It is marked as capital A, and I have learnt how to use the iPad.
Mr. Sybil, just wondering if you could just look at the issues that were framed.
Ladyship, I can't hear you.
Look at the issues that were framed once so that we know the perspective in which you're arguing. The issues that were framed for reference to the Constitution.
I can read those.
Can we just to give
Yeah,
us
I think it's a good idea.
call before we
Reference
proceed
order.
further?
Yes, reference order, your lordships will have that. Order compilation, Malaj. PDF page 28.
Order compilation.
Orders compilation, PDF page 28. And the questions start at page 30.
Is the order dated?
It is on order dated, Malaj, 23rd of August, 2022.
Page 28.
Page 28, Malaj, and the relevant part, the question starts at page 30 at the bottom.
Order compilation, right?
28.
PDF page 30, Malaj.
28.
Your ladyship has it? Justice Shah, Malaj.
Yes.
May I, Malad? A, whether notice for removal of a speaker restricts him from continuing with disqualification proceedings under the 10th schedule of the Constitution as held by this court in Nabia. Malad, I've already argued that. So Lordships, Malad, have deferred your Lordship's judgment on that. So we'll skip that for the moment. B, whether a petition under Article 226 or 32 lies inviting a decision on a disqualification petition by the High Court or the Supreme Court, as the case may be. That's the question that I have already formulated in different, the language is somewhat different, but the intent is the same. Then C, can a court hold that a member is deemed to be disqualified by virtue of his or her actions absent a decision to the speaker? Actually, B and C are together, Malad. They are interlinked.
Per se cases.
Yes. The language is somewhat, Malad. D, Malad, what is the status of proceedings in the House during the pendency of disqualification petitions against the members? Malad, it really doesn't clarify what it means. What is the status of proceedings? What it means is that can members against whom there is a disqualification petition pending have a role to play in the House while it is pending? Otherwise, you can topple any government you want. Then E, Malad, if the decision of a speaker that a member has incurred disqualification under the 10th schedule relates back to the date of the action complained of, then what is the status of proceedings that took place during the pendency of a disqualification petition? Now, Malad, this question only arises if you allow proceedings to go on. If you don't decide on the disqualification before, then this question arises, because if at a later point in time, you consider them to be disqualified relating back to the date when their act led to a voluntary giving up membership of the party or violation of the whip, then, Malad, what happens to the intervening proceedings? A government has been formed, actions have been taken, policy decisions have been made. Would it not be better, for the purposes of, I personally believe, democratic traditions, that you should await your hands till the disqualification is decided first, because this problem will not arise then. Then, Malad, F, I think, is very, very important. What is the impact of the removal of paragraph 3 in the 10th schedule? According to me, that's central to the entire issue. Because now you don't have a split. The issue of a split doesn't arise. Which is why, if you want to go to the Election Commission, there has to be a split in the party, not a split in the legislature. That is not on record. No such split. So this is central, and we'll interpret paragraph 4 also in that context. Then G, what is the scope of the power of the Speaker to determine the whip and the leader of the House legislative power? What is the interplay of the same with respect to the provisions of the 10th schedule? Well, it's actually, again, convoluted in its expression. In simple terms, it means that how is a whip appointed and how is a leader in the House appointed? Is it a role of a political party, or is it something that the legislative party decides? Can majority of the legislative party members decide, I'll change the whip tomorrow? Can't be. So what has happened in this case, and I'll come to the facts, Mullahs, that sitting outside the House, X number of people said, you are no longer the whip. And those are members of the legislature only. Mullahs, I can give your lordship's documents to the effect. What happens is when a leader of the House is appointed, the letter that is given to the Speaker is that the party hereby decides that this person will lead the house for the party. It's not the members of the legislature don't decide these issues. Similarly, whip. Because the whip is the bridge between between government or the opposition, whichever party it is, and the house, members of the legislature. That's why your lordships will see that nowhere in the constitution does the word political party is referred to, except in the 10th schedule. Because in the constitution, you're dealing with institutions. You're dealing with an institutional framework within which all political parties function. In the 10th schedule, you're dealing with framework within which a legislative party functions in the context of the political party, resulting in disqualification. Then, Malat's H. Are intra-party decisions amenable to judicial review? I don't think that question arises. There's no intra-party decision in the legislature. So your ladyship is right that we need to look at some of these questions. Then I, what is the extent of discretion and power of the governor to invite a person to form the government and whether the same is amenable to judicial review? Well, the governor's actions are always amenable to judicial review. That's not an issue at all. Question is, what should a governor do in the context of disqualification petitions pending and which are yet to be adjudicated upon? As a governor, Malat, who he is a constitutional authority, he needs to protect the constitution and the laws. In this very state, a governor, Malat, in the early hours of the morning, gave an oath, to the oath of office, Malat, made somebody a chief minister. And by the early morning, Malat, on daylight, he had to resign. Governors, and I say this with respect to all the institution of the governor, that governors have, in my respectful submission, acted far beyond their constitutional responsibilities, as we have seen, as I have seen in the recent past. That may not be a proposition that the other side will accept, but I'm giving only my view of the matter. It is unfortunate that governments are actively involved in the politics of the country. Then, Malas, the last one. What is the scope of the powers of the Election Commission of India with respect to determination of a split within a party? That's where, Malas, the question of para 15 of the symbols order comes in. Let's kindly now come to the written submissions of the petitioner. And the list of dates is at page 108. PDF 108.
Submission.
That is A, right? A, petitioner written submission.
yes, A. PDF 108.
Written submissions on the petition.
Written submissions, no?
Yes,
You are referring to written.
yes,
submissions,
yes.
Not additional written submissions. Not additional written submissions.
A, madam, A,
A.
page 108, PDF.
Mr. Sibyl, what we could also do is that, of course, we've seen the broad points of reference, but ultimately we'll need to focus, narrow down the reference to the issues which you want to focus on.
Yes.
And maybe if you could, during the course of the afternoon, share that with the other side. We can have their feedback so that we narrow it down to certain specific issues. Because many of the issues which have been framed in the reference order may not strictly arise.
Yeah, it's not necessary. I
So
said that
let's
already.
sort of structure that so that it'll lend some clarity to.
Well,
submissions to
let
for
us do that in the evening, well, that would be much easier for us.
difficulty.
If your lordships will allow us, because I'll consult my colleagues.
Yes, absolutely.
We'll
Also,
give some
you can
agreed
sit down,
issues, Malad,
in
yes.
the evening and give us some agreed issues which will arise.
Because afternoon may not be the most appropriate.
Evening would be fine.
Yes, we will,
Right. And also then we can have some idea about, the time schedule, how long would you take? So that then we can so restrict them as well and to certain time.
Malad, this side, Malad, will take 3 days, Malad.
Mr. Sibyl, how long would you take? About 3 hours or so today?
No, Malad, I'll take much more tomorrow too.
Mr. Sibyl, we'll have to have structured arguments.
All right, it'll be structured, Malad. I'm not going to repeat myself at all.
Same.
Your lordship knows I myself, Malad, reduced,
After Mr. Sibyl, after you conclude, Dr. Singhvi will.
Dr. Singhvi and then Mr. Kamath, my colleague, Mr.
So
Kamath.
why don't, Dr. Maybe we could do this. We have about an hour and 15 minutes before lunch, and you get 2 hours after lunch today. That's about 3 hours and 15 minutes. So maybe if you could conclude today by 4 o'clock, then we can give Dr. Singhvi until lunch tomorrow.
Yes.
And then a little supplement to half an hour after lunch for Mr. Kamath.
Yes.
And then they can start tomorrow afternoon. We are breaking at 3:30 tomorrow. So they get about an hour and a half in the afternoon. And maybe on Thursday, they can conclude by maybe lunch. And then we give you.
We'll try that, Malad. We'll try that. No issue, Malad. We'll certainly try and speed it up. I mean, I just think, Malad, your lordships may have questions yourselves.
No, of course. If we find that, of course, there's a little change in the time schedule, we can certainly do.
Then, Malad, your lordships will also have to decide on the NABAM reference at some stage, what your lordship wants to do, because
Yes.
that sort of opens up another.
So we'll look at the list of dates.
Yes, Malad. So on 1966, Shiv Sena, founded by Bala Saheb Thackeray, to espouse the ideology and legacy of whatever, and has been recognized as a state political party by the Election Commission. Bala Saheb Thackeray was the president, Shiv Sena Pramukh of the Shiv Sena from its very inception and continued in the role till his demise on 17th November 2012. After the demise of Bala Saheb Thackeray, Uddhav Thackeray was unanimously elected to be president, Shiv Sena Paksh Pramukh of the Shiv Sena political party, and has continued to hold the position. At present, Shri Uddhav Thackeray unequivocally continues to be the Paksh Pramukh of the Shiv Sena, president of Shiv Sena, which is the highest position as provided in the constitution of Shiv Sena. Copy of the constitution is annexed. 85, in view of the repeated defections of elected MLAs, MPs, and with a view to curb horse trading of an elected representative, the constitution was amended to include the 10th schedule by virtue of the 52nd Amendment to the Constitution with the following statements and objects. The evil of political defections has been a matter of national concern. If it is not combated, it is likely to undermine the very foundation of our democracy and the principles which sustain it. With this object, an assurance was given in the address by the President to Parliament that the government intended to introduce in the current session of Parliament an anti-defection bill This bill is meant for outlawing defection and fulfilling the above assurance. So nothing in the 10th schedule should be interpreted to give credence to a defection. Nothing in the 10th schedule should be interpreted to somehow legalize a defection. Give credibility to that process, because the whole object of the act is to ensure that there are no unprincipled defections. Well, there is an elected government. The attempt of the court and of the institution of the governor should be to allow the elected government to function till such time as a person is either disqualified or not disqualified. Right? And if there is a disqualification petition, that should be allowed to be decided. Because if you don't allow that to happen and you pass an order like you did on the 27th of June, unfortunately, it's the judicial order that led to this. It is that judicial order that led to this. Had that not been passed, we wouldn't be here. And if the speaker had been allowed to decide, and they would have gone up in appeal if there was a decision against them, or somebody else would have gone up in appeal. Yes. So, Malad, 7th of April, the 10th schedule was amended by the 92nd Amendment, and paragraph 3 thereof, which permitted 1/3 members of the legislative party to split, was omitted. Split is no longer available as a defense against disqualification under the 10th schedule. Malad, please mark that. The defenses available were only two. That I have 1/3 of the legislative party has split, pursuant to a split in the political party. It is not a split of the legislative party. Paragraph 3, and I'll read that, Your Lordships, it is a split in the political party, resulting in 1/3 of the members in the legislative party, which gives them a defense to say that they cannot be disqualified. Similarly, with paragraph 4, it's a defense. If I am 2/3 and there's a merger of the party, it's a defense saying, now I am entitled to be that party. That is part of the new party. Either a new original party or part of the merged party. That's a defense. That's why I indicated to Your Lordships, now there's no question of majority, minority, 1/3, 2/3, no, not relevant. If there's a split. Because what? The purpose of the defection law is to ensure that there is no unprincipled defection. Then, Malads, 23rd of January, organizational elections of the Shiv Sena political party for term 2018 to 23 were held, wherein Uddhav Thackeray was elected as president. The results were duly communicated in the prescribed format to the Election Commission on 27th of February 2018. Well, the Election Commission, and that, Your Lordships, is not relevant here. Election Commission in its order says, I don't have your constitution. Therefore, I will not consider that you are about the organizational wing structure. I will not consider it at all. So I go only by what is the legislative majority, and the legislative majority is 38 people from Eknath Shinde group, therefore they get the symbol. Anyway, that's another matter. Then, Malads, October 2019 elections in the 14th Legislative Assembly of Maharashtra were held. The seat distribution in the said election inter se of political parties is following. Your Lordship knows this. You have seen it before. Then, Malads, November 2019, a post-poll alliance was formed between the Shiv Sena, the NCP, as well as the INC called Maha Vikas Aghadi to form a stable government in the state of Maharashtra, with the president of Shiv Sena, Uddhav Thackeray, being sworn in as the chief minister. 23/11/2019, prior to the swearing in of Thackeray, the governor hastily sworn in Devendra Fadnavis early in the morning as the chief minister of Maharashtra. This honorable court in Shiv Sena versus Union of India directed an immediate floor test, and Devendra Fadnavis resigned before facing the floor of the House. This only indicates how governors, Mullahs, have been conducting themselves. How can a governor have sworn in somebody as a chief minister without knowing that he has majority in early hours of the morning?
This order is on 23rd November,
Yes.
Supreme Court's order?
Yes. Oh, the order, I just. 2019, 10 SCC, 809.
Tell me later.
Yes. Then it's mentioned there. Anyway, April, May 2020, governor has been at loggerheads with the 2511. Oh, 2511, Sunil Prabhu. Now this is important. 2511, Sunil Prabhu is appointed as chief whip of the Shiv Sena Legislative Party with the blessings of Uddhav Thackeray, president of the Shiv Sena political party, and the same was duly notified to the Speaker of the Maharashtra Legislative Assembly. Well, that, Your Lordship, may actually, if Your Lordship don't mind, look at that document. Or do you want to read the dates and then later?
Please
That-
read please read the entire dates.
All right, all right. Then April, May 2020, the Honorable Governor has been at loggerheads with the MVA government and has almost created a political crisis. Governor was sitting on Shri Uddhav Thackre's recommendation for nomination to the Maharashtra Legislative Assembly, despite a period of 6 months as an unelected member was about to expire on 27/5/2020. Further, the governor had blocked holding of the speaker's election. No speaker's election took place. Well, he was not a member of, there was a seat for in the legislative council which had to be, he had to be elected from that seat. He wouldn't hold the election for almost 6 months. This tells you, how constitutional authorities are acting. First you swear in somebody, he resigns the next morning, or then you have this problem. The BJP has been attempting to create divisions within the Shiv Sena, 20th June 2020, in the recently conducted MLC election, wherein despite having the requisite number of MLAs on its side, the MVA alliance led by Shiv Sena lost a seat to the BJP. This was because of cross-voting within the MVA and particularly within the Shiv Sena at the behest of the BJP. I'm not going to rely on these facts, because this is disputed. So that these facts I'm not going to rely on. It was widely reported in the media that Eknath Shinde, who was then the cabinet minister of urban development and public works, has along with certain others delinquent MLAs of the Shiv Sena gone into hiding in the BJP-ruled neighboring state of Gujarat. Then 21/6, these are the undisputed facts that now start. To contain and allay the apprehensions that were arising in the party post the MLC elections, an urgent meeting of the Shiv Sena Legislative Party was called on the 21st of June. Eknath Shinde, along with certain other delinquent MLAs, did not attend the above-mentioned meeting, dated 21st of June. The party resolved in the said meeting to remove Eknath Shinde from the position of the leader of the Shiv Sena Legislative Party and appoint Ajay Chaudhary instead. Now, this is interesting because this is a matter which Your Lordship has to constitutionally consider. So a faction, which is a legislative party, decides that I will change the whip. Constitutionally impermissible. Then, the decision, then Eknath Shinde, along with certain other delinquent MLAs, did not attend the meeting. Party resolved in the said meeting to remove Eknath Shinde from the position of leader of Shiv Sena and appoint Shri Ajay Chaudhary instead. The decision to remove Eknath Shinde was communicated by Uddhav Thackeray to the Honorable Deputy Speaker. After due verification, the Deputy Speaker accepted the change of leadership of Shiv Sena in the House. The reason why this happened was, because, as Your Lordship knows, he had to be a member of the Legislative Council because there was no seat in the Assembly. So the then Chief Minister became a member of the Legislative Council. Therefore, in the meantime, somebody had to be appointed, as the leader of the House, because they were the treasury benches. So Eknath Shinde was the leader of the House. And he was removed from his position of leadership by decision of the party. And the Deputy Speaker was told about it and he accepted it. In the larger interest of the party, it was thought fit to call for another legislative party meeting to give one more opportunity to the MLAs who were absent in the meeting on 21st June to show their loyalty and support to the original political party. Hence, another meeting of the SSLP was called. Individual notices were issued to all the MLAs of the Shiv Sena, and it was made adequately clear that, quote, failure to participate in the meeting without providing valid and adequate reasons in writing, communicated in advance to the underside, will result in consequential action against you under the relevant provisions of the Constitution. So they were told. On 22nd of June, despite the importance of the meeting called on 22nd June, aimed at consolidating the SSLP's strength to contain any possible horse trading, several dissident MLAs did not attend the meeting. Instead, the delinquent MLAs sitting in BJP-ruled states sent communications rejecting the holding of the meeting as illegal, which itself shows that those MLAs had been working contrary to the diktats of the original political party. 22nd of June, Sunil Prabhu, in the capacity of Chief Whip, responded to the communication dated 22nd of June of the delinquent MLAs rejecting the reasons given for their absence from the SSLP meeting as an afterthought, frivolous, backdated, and proof of them acting contrary to the interests of the original political party. That's the notice that your lordships read, 21st of June, dated 21st of June. Received on 22nd of June at 11:30 a.m., but dated 21st June. Eknath Shinde wrote to the Deputy Speaker communicating his appointment as leader. So now, the legislative party or a majority of the legislative party can decide who they're going to be the leader of the party in the House, of the party, sitting in Assam. On 22nd of June, simultaneously, a purported notice for removal of Deputy Speaker Narhari Zirwal under Rule 11 of the Maharashtra Assembly Rules, read with 179, was received at the Legislature Secretariat, expressing no confidence in the Deputy Speaker. Notice was hand-delivered by an unknown courier and not by any MLA. It is also relevant to note that none of the purported signatories of the notice had personally delivered any such notice, nor it was sent through the registered email address of any of them. The Shiv Sena Legislative Party in its meeting took note of Shri Eknath Shinde and rebel MLAs and the fact that they had indulged in anti-party activities and were trying to destabilize the MBA government. In view of this, it was resolved that the Shiv Sena Legislative Party meeting at the then CM's residence, that necessary legal action shall be taken under the 10th schedule against the errant MLAs. Now, who is CM? CM Maharaj is a member of the Legislative Council. He is also the Param Pramukh, Paksh Pramukh. So he is the political leader. He is the one who decides. On 23rd of June, Sunil Prabhu filed disqualification petitions under Para 21A, seeking disqualification of Eknath Shinde and 15 other delinquent MLAs of Shiv Sena. 24th of June, it was widely published in the news reports that the rebel MLAs led by Eknath Shinde were acting in collusion with BJP, and their entire logistical arrangement in Guwahati was made by the BJP leaders. 24th of June, Secretary of Maharashtra Legislative Assembly received an email from an advocate named Vishal Acharya attaching notice for removal of the speaker dated 21st of June. On the same day, the Secretary of the Assembly communicated the decision of the Deputy Speaker to the email of Vishal Acharya, refusing to take on record the communication dated 22nd of June until the genuineness and veracity of any such communication and its signatories was ascertained. 25th of June, one of the dissident MLAs, Deepak Kesarkar, in a live interview declared that the dissident MLAs had formed a new group and named it Shiv Sena Balasaheb, and had also announced that they will have a separate leader whip, office, and everything else, just like a party has. 25th of June, Honorable Speaker, after due verification, was pleased to issue notices to the delinquent MLAs under Rule 6 of the Maharashtra Legislative Assembly disqualification on ground of defection rules 86, read with the 10th schedule of the Constitution, asking the delinquent MLAs to file their replies by 5:30 on the 27th of June, 2022. On 25th of June, the national executive meeting of the Shiv Sena was held. The said meeting was attended by over 163 representatives of the National Executive, and the leadership of Uddhav Thackeray as the president of Shiv Sena was unanimously and equivocally accepted by the National Executive. 25th of June, Sunil Prabhu filed an additional affidavit in the disqualification proceedings inter alia, containing the media reports that showed the hobnobbing of the delinquent MLAs with BJP leaders. 25th of June, Sunil Prabhu filed disqualification petitions against 2 independent MLAs and 1 MLA belonging to the Prahar Jan Shakti Party. The petition against the independent MLAs were filed on the ground that they gave up their independent status by taking part in the resolution dated 21st of June, passed by the rebel MLAs, and signing the said resolution on the letterhead of SSLP. Also, the ground taken against BJP MLA was that the said MLA voluntarily gave up membership of his original political party by taking part in the said resolution dated 21st June and by signing the same on the SSLP letterhead. 27 June, issuance of the notice of 25th June by the Honorable Deputy Speaker came to be challenged by the 16 MLAs, including Shri Eknath Shinde, who filed a writ petition under 32. The said court, the Honorable Court, by the interim order dated so-and-so, in writ petition so-and-so, was pleased to, in the interim, direct this. Thus, meanwhile, as an interim measure, the time granted by the Deputy Speaker of the Assembly to the petitioners or other similarly placed members of the legislative party to submit their written submissions up to today on today 5:30 p.m. is extended till 12/7. Well, just kindly note the language here as an interim measure. They have not filed a reply till date. We are now in February 2023. They have not filed a reply. Now, Malaj, prior to the passing of this judicial order, Malaj, all that happened was happening outside of Bombay, outside of Maharashtra, in a state in the Northeast. And by whom? By these members of the Legislative Assembly, that's all. There was no party in sight. There was no meeting of any party. Nobody called for a meeting of the party. And these are undisputed facts, Malaj. These are not disputed facts. Can the 10th schedule countenance a situation where, because of whatever reasons, Malaj, we don't want to go into it, a majority or even a minority of MLAs are just, Malaj, let's forget the majority, Malaj. Supposing a minority, you don't sometimes need the majority to topple a government. You'd only need a minority. Supposing it's a minority, Malaj, and the minority outside the state of Maharashtra says, I have formed. I am the political party. And then a judicial order is passed, Malaj, on a disqualification petition. Then no. If a petition is filed, you can file your reply after 10, 15 days, Malaj. In the meantime, the minority gets in touch, Malaj, with the other party, topples the government, a new chief minister is appointed. Can you ever imagine that the 10th schedule would allow that? Can it ever be countenanced, Malaj? This is harakiri. This is legislative harakiri. Political harakiri. And you can't interpret the 10th schedule, Malaj, in this particular fashion to allow an elected government to fall. That's why I said it is judicial orders of this court that resulted in this. Then, Malaj, 27th of June. As several other members of the SSLP had also openly indulged in anti-party activity. Now, can anybody say, Malaj, that this is not anti-party or this is not giving up membership of the party? One of you sitting there say that we are forming a new party called Shiv Sena Bala Sahab. And you are sitting in a state ruled by the opposite, ruled by a party, Malaj, which was in the opposition. First you go to Gujarat, then you go to Assam. There's no dispute on that. These actions per se amount to giving up membership of the party, apart from the fact that you don't attend the meeting on 21st, 22nd of June. So what is the speaker going to decide? What can he decide? Given these facts. Then 28th of June, Malaj, late in the evening, the leader of opposition in the state of Maharashtra, Devendra Fadnavis, went to meet the governor and requested him to hold a floor test after the stay. That's where the role of the governor comes in. On 28th of June, immediately after meeting Devendra Fadnavis and with utmost haste, the governor sent a communication dated 28th of June, though received in the early hours of 29th of June to the then Chief Minister, directing him to face a floor test in the House on the very next day, 30th of June. It is relevant to note that the Honorable Governor did not even attempt to ascertain from the Chief Minister whether he enjoyed the majority of the House. On 28th of June, the Governor, by way of a separate communication dated 28th of June, which was received in the early hours, directed the latter to forthwith on 30th June to convene the assembly and hold a floor test. 29th of June, Sunil Prabhu filed a writ petition before this honorable court seeking a stay. So, as we said, please stay the matter. Please don't allow this to happen. Of the directions of the floor test in view of the fact that the disqualification petition of 42 MLAs under the 10th schedule are pending. By order dated 29th of June, in writ petition so-and-so, this court was pleased to direct as follows. Having given a thoughtful consideration to the rival submissions, we do not find any ground to stay convening of the special session of the Maharashtra Assembly. How? Vidhan Sabha on 30th June, tomorrow at 11 a.m. and with the only agenda of a trust vote. So therefore, you give legitimacy to those against whom disqualification petitions are pending, and such legitimacy that they are able to topple the government by colluding with another party, which is in opposition in that very state. That's the effect of the judicial order. So first, stay the proceeding before the deputy speaker, then allow this collusion and get an elected government toppled. What used to be the misuse of 357 has now been substituted by the misuse of the 10th schedule. 356 was now misuse of the 10th schedule. And the proceeding of the trust vote to be convened on 30th of June shall be subject to the final outcome of the instant petition. That's another interesting thing, brothers. Proceeding of the trust vote shall be subject to the final outcome of the instant petition as well as the writ petitions referred to above. So therefore, brothers, every action of the governor resulting in a new government having been formed is subject to your lordship's decision in these petitions. So you cannot give it the color and clothe it with legality, because the judicial order itself says that it's subject to. So you cannot say now the trust vote has happened, now a chief minister has been installed, now a government is in place, now you can't do a thing about it. The special session of Maharashtra Vidhan Sabha shall be conducted in accordance with the directions that contained in the communication dated through 28th of June of the Governor of Maharashtra. Then 29 June, Chief Minister Uddhav Thackeray resigned, because he knows the writing was on the wall, having given legitimacy to those who then 30th of June at around 3 p.m., Eknath Shinde and Devendra Fadnavis met the governor and staked claim to form the government. This is also anti-party activity. No evidence is required on this. Then 30th of June, the governor, without taking into account the fact that the membership of Eknath Shinde itself was in dispute, here again the question of the governor comes in dispute. In the imminent disqualification petition pending against him, swore Shri Eknath Shinde in as the Chief Minister and Devendra Fadnavis as the Deputy Chief Minister of Maharashtra. The Honorable Governor thereafter directed Eknath Shinde to prove his majority on the floor of the House. We knew that everybody knows that he would have the majority thus. You can fool the constitution, but not the arithmetic. Then the governor, without taking into account the fact that the members, and I've read that. Then 30th of June, due to their anti-party activities which unquestionably amounted to relinquishing membership of the Shiv Sena political party, Shri Sinde, Tanaji Sawant, Uday Samant, and Gulab Rao Patil were removed from their positions in the organizational setup of the party by the undisputed president of the Shiv Sena, Shri Uddhav. Well, let's just note here, no meeting of any political party took place at the instance of Eknath Shinde. And you will see that tomorrow in the petition before the Election Commission. That alleged meeting, which I'll show is bogus, happened to have taken place on 18th July. After all this was over. And the petition for getting the symbol was filed on the 19th July. On the very next day. Then, Malats, one second. Yeah, then, Malats, 1st of July, 2022, Shiv Sena Secretary sent a letter to the Election Commission intimating the authority regarding the removal of Eknath Shinde from the positions of Shiv Sena and change in the organizational setup of Shiv Sena thereto. Also, by the separate letter, the Shiv Sena Secretary intimated the ECI regarding the removal of Tanaji Sawant and Uday Samant from the organizational position of Shiv Sena. Similarly, the Shiv Sena Secretary sent another letter to the Election Commission of India intimating the authority regarding the removal of Gulab Rao Patil from the organizational position of Shiv Sena. On 1st of July, an application for directions, IA such and such, was filed by Sunil Prabhu in the present writ petition seeking an interim order suspending the delinquent MLAs against whom disqualification petitions have been filed till the final adjudication of the 10th scheduled proceedings. The said application was mentioned before this court for urgent interim listing, wherein this honorable court directed to list the application along with the writ petition on 11th of July. Then 2nd of July, the Principal Secretary, Maharashtra Legislative Assembly, circulated working order for conducting election to the office of Speaker on 3rd of July. The said agenda showed that the name of Rahul Narvekar was proposed by the BJP MLA and the name of Ranjan Prabhar Salvi was proposed by Shiv Sena. So this Rahul Narvekar was proposed by a BJP MLA because he happened to be a member of the BJP. Then 2nd of July, Sunil Prabhu, acting as Chief Whip, issued a whip. Now, till that day, Sunil Prabhu is still the whip. Acting as Chief Whip of SSLP, issued whip to the members of SSLP regarding the election of the Speaker, scheduled on 3rd of July. All the party members were asked to remain present in the assembly and vote for the Shiv Sena candidate, Rajan Salvi. Sunil Prabhu issued a further whip to the members of SSLP regarding confidence motion, scheduled on 4th of July. All the party members were asked to remain present in the assembly until the end of the session and vote against the confidence motion. Well, as your lordships must just keep one thing in mind. It's not their case that they merged with any party. It's their case that they belong to the Shiv Sena. So if they belong to the Shiv Sena, then how can they disobey the whip? And vote for a BJP candidate against the Shiv Sena member? There is no evidence required here, Maharaj. Then on 3rd of July, Ajay Chaudhary, acting as the leader of the SSLP, submitted a letter to the Deputy Speaker requesting him to conduct the election of the Speaker of the Legislative Assembly by division of votes. Ajay Chaudhary on the 3rd of July submitted a letter to the Deputy Speaker requesting that the votes cast by the members of the Legislative Assembly who have incurred disqualification should not be considered during the election of the Speaker. 3rd of July, the election for the office of the Speaker of Maharashtra Legislative Assembly was held. Rahul Narvekar, the candidate for the Bharatiya Janata Party was unconstitutionally elected as the Speaker of the Maharashtra Legislative Assembly after getting a total of 164 votes. During the elections, it was recorded by the Deputy Speaker that 39 delinquent MLAs of Shiv Sena Legislative Party, led by Eknath Shinde, had voted against the party whip. Now, at this point in time, there is no other whip. Now you will see on the evening of the 3rd, after
How many votes did the rival candidate poll that day?
sorry,
Of July. How many votes did the rival candidate poll on the 3rd of July? Speaker.
that's all. We are not Mullahs on majority minority. Yes, that's correct. I'm glad that my learned friend pointed it out, Mullahs. Correct.
But therefore, if these 39 are excluded from 164,
Mullahs,
will they still have 125?
I am not Mullahs on that. I'm only saying that they voted against the whip, therefore they are deemed to be disqualified. That's all I'm saying, Mullahs. I'm not saying, Mullahs, whether he would have, supposing, Mullahs, all of them are disqualified, because on that particular day, they voted against the whip,
These 39.
all 39.
No, but therefore, if you exclude these 39
Yes,
from the 164,
yes.
they're still down to, they still get 125, right?
Facts are-
Your Lordship is right, Mullahs. I am, at the moment, Mullahs, I am not challenging. At the moment, Mullahs,
Because this comes soon on the heels of the trust vote, which takes place on the 30th.
yes.
So this is now an indicator within 3 days.
Trust vote happened on the 4th.
Because Mr. Sibal,
Trust
you
vote
don't,
happen on the 30th, Mullahs.
right, you don't, ultimately, you don't face the trust vote.
Yeah, I don't, Mullahs. So therefore, it is held on the 4th. And we challenge the trust vote also. We've challenged all decisions, the election of the speaker, trust vote, whatever. All that is challenged. Mullahs, the question is, at the moment, Mullahs, we are dealing very, very limited issue. One, should the courts have given time?
That's a separate issue because
Separate.
it's an order which is an interim order.
Yeah, it's an interim order. What was the result of that, Mullahs? That these people were able to topple the government without the disqualification petitions having been decided. There was an elected government, Mullahs, which was in power. The 10th schedule was used for the purposes of toppling an elected government. And supposing tomorrow, Mullahs, your Lordship holds by these actions, which are uncontroverted, that they disqualify themselves on both counts, 21A and 21B, what will be the result? And if your Lordship holds otherwise, let's assume against me, then this will be, Mullahs, you have given them a model to topple every elected government.
But Mr. Sibal, are we not still down to, if you are really looking at the numbers here, are we not down to the situation where the speaker's election at least indicates that because 38 was sought to be disqualified, there were disqualification petitions against the 38. Now, if you exclude the 38 for a moment from the 164 who voted in favor of the resolution for the speaker, you still have a situation where that's in very close proximity to the date on which the trust vote was to be held on the 30th.
Yes,
Now, you resign, right, on the 30th.
yes.
And therefore, is this not really clearly an indicator that even excluding these 39,
That's all right. The speaker could have been, Mullahs. Yes, I'm not disputing that, Mullahs. I'm not sure what the arithmetic is.
That's what my Lord.
Half 145 is the halfway mark, Mullahs.
That's what my Lord the Chief Justice
You
asked.
deduct 34, you are below, Mullahs. I'm sorry. In fact, the arithmetic is the other way.
No, my Lord's 288 was the total.
Yeah, just
What's
let-
the number?
just give,
288
We'll just
was the
give you the
total strength of the
arithmetic.
assembly. The
Mr. Fowler.
actual,
just 1 second.
yes,
Total strength of the assembly,
288.
that was there from Mr. Sibal's chart, which we
Right.
saw.
Actual votes received by Mr. Narvekar were 164, which is over the 50% mark of 144.
Just 1 second, just one second. Total
So
strength
the
of the
half
assembly.
mark would be 145.
Just a
1 second.
Yes.
164.
So if 144 is the halfway mark, 145, 164 votes were received by Mr. Narvekar. If the strength was taken to be 288. If 39 MLAs are excluded from the strength of the Legislative Assembly, the effective strength comes down to 249.
249.
And out of those,
Just 1 second.
249, half of it is
249 and then.
And the effective votes received by Mr. Narvekar were 125, which is over 50% of the votes required. So under any circumstance, even if 39 MLAs are removed.
Plus, there were only 16 disqualifications.
Yes, plus on that.
Ready? Wow. Mia, can you send me that? Sure.
Mia, can you send me that?
Mia, can you send me that?
Will you send me that? Not you, Mia.
Hey, can you send me that? Sure.
Mr. Rajkumar and Ms. Vagay, to please take your seats on the dais. I request the audience to please not leave the room because we will start immediately. And you won't want to miss out on this discussion with a panel of such luminaries. So I request the dignitaries to please, we'll just put up the nameplates in a bit. We're not taking a break. We'll be starting as soon as the dignitaries take their position on the dais.